Yes, I believe she is misusing it, let's call it.
Yeah, this does frustrate me, and we saw something similar to that in Depp Heard, where the ACLU aligned itself with Amber Heard and put its reputation on the line to protect what the jury found to be.
What if Blake Lively's victory wasn't really a victory at all? Bryan Freedman just dropped a bombshell calling out what he says is Lively's false victory tour. But why is this Hollywood insider so furious? And what does the court ruling really reveal about the truth behind her claims? Stick around. They don't want you to know what comes next.
Yes, I believe she is misusing it, let's call it, in order for a underlying agenda and a fight that she picked that probably she regrets picking.
Yeah, I mean, you've always sort of said that, because we've talked specifically, we talked in our documentary, which stay tuned, we may be touching upon things that we touch upon there. That's fine. But the grade of the case, please don't hold back. But there's always been this other thing about the harassment claim doesn't even matter if it's true, because in California, if she levels a SH claim, as we call them, if he retaliated in any form, even after a harassment claim was made, he could still be found guilty, correct? So whether the SH was true or not, we already have to sort of contend with that. Is that true?
Right. So you have two things. One is the harm because of the act itself, and then the harm because you complain about the act itself. But there's a qualifier. You complaining about the act has to be done in good faith. Can't just be, just thrown out there just because. And it leans heavy on for the accuser, right? If the accuser just has any good faith basis for this, you cannot retaliate against her. So yeah, there will be viewed differently in two separate columns.
So this 47.1, I want to go back to. This communications made with, as stated, civil section 47.1, communications made without malice, further provide that this section shall only apply to an individual that has, or in any time at reasonable basis, filed a complaint of SAH discrimination. These requirements, communication be made without malice and without reasonable basis, in fact, are why Lively's arguments fall flat. And as alleged in the FAC, Lively fabricated her allegations of SH, either with wholesale or by exaggerated benign and not harassing interactions, in a concerted malicious effort to seize control of the film and later restore her reputation after a well-publicized series of marketing missteps that sullied her reputation. What's also interesting is it does feel like the first time they're also even saying, yeah, now they hijacked the film and the franchise. They really are finally, it does feel like, bringing all their things together here to reiterate, because you've said it before, it's not harassment if it's just one of those claims, right? It has to be all of them under the same umbrella is what makes it more of that harassment claim. So do you agree with what they're saying here? Or do they have a better shot because of the attempted, effort to seize control of the film and everything else that he's saying here?
Right. So we've spoken what Baldoni's alleged to have done is not like one super serious, boob grab, right? It's not that. It's these kind of nefarious things which shouldn't happen in the workplace, but they have to happen over a course of time to meet the legal standard. Now, once this underlying story kind of comes up, her motivations for bringing these quote unquote unlawful things during those stories of them trying to take over the film now give context to his counterclaim. And I believe that it is a huge deal for the judge to see in order for the judge to make a determination. Now, what is very interesting and most people don't kind of understand is that judges at this stage where they're just like, well, I'm just looking at your guys' complaints. The judge can't really make a credibility finding. He has to assume what is in the complaint is true. So that is why Baldoni's attorneys are like, this doesn't have a shot because of how detailed the complaint by Baldoni is. Judge cannot make opposite finding because he has to, or she has to make an assumption that everything in that very well detailed complaint is true. So it just can't happen for Lively the way she wants to.
Why is Blake Lively suddenly everywhere, celebrating her court triumph like it's the victory of the decade? From magazine covers to late-night talk shows, she's been leaning hard into the narrative of a victim turned hero. A woman squaring off against injustice and coming out on top. Her interviews strike the same chord again and again. She overcame adversity. She fought the good fight. And most importantly, she won. But is that really the full story? Take her latest sit-down interview. There she was, teary-eyed but triumphant, recounting how this legal battle was a fight for her voice to be heard. She called it a symbolic moment, a win not just for her, but for others who faced similar struggles. The headline screamed empowerment, and social media lit up with praise. You might even be rooting for her. But when digging just a little deeper into the court ruling itself, things stop adding up. Let's talk specifics. Freedman has made it. Cleary's not buying Lively's version of events. He's called her celebration nothing short of a false victory tour. And if you think that sounds harsh, wait until you hear what he's suggesting about the ruling itself. While Blake projects this image of a decisive triumph, the actual court decision seems far more nuanced. According to insiders, the ruling didn't exactly hand her the sweeping victory she's selling to the public. Part of it involved procedural outcomes, a far cry from the dramatic win she's portraying. Here's where the cracks start to show. In one bold statement, Lively claimed the court validated every aspect of her case. Yet Freedman sees this as pure spin. He's frustrated, some say furious, over how Lively's team has framed this as an open and shut endorsement of her position. The truth, according to Freedman, is messier. He's hinted strongly that key pieces of her claims were actually left unresolved or worse, dismissed outright in favor of technicalities. That's the case? Why hasn't that part made it into Lively's victory narrative? And it gets more interesting. Freedman's frustration isn't just about the differences in interpretation. It's about the whole campaign surrounding her. He's pointed to how Lively rolled out her public appearances right after the ruling with careful timing that practically screams strategy. From emotion-filled remarks to choice sound bites dominating entertainment news. It all begs the question, is this a legal battle or a PR mysteris? In the end, it's impossible to ignore Freedman's questions. He's teased evidence that could unravel everything, reshaping how this so-called win is perceived. Could her victory really be more about media control than legal substance? That's the thought he's pushing, and whether or not he's right, it's enough to get people talking. But Freedman isn't just throwing accusations into the void. What he reveals next changes the game entirely.
So, yes and no, but based on prior conduct that's been happening and prior comments about just what has been happening in the case in general, and been a little cavalier about certain things. To me, this implicates three things. One is, the reality is, if you get subpoenaed and they ask for documents, you can assert your rights that are recognized in the federal court, where this is that you can protect your sources because it doesn't get in criminal activity. Two, it is kind of like as a shot across the bow to not only you, but other media folks that are on YouTube or TikTok or traditional media to like, well, wait a minute, what if I, report the news and then I have a comment as to, who's on the side of right and wrong? Am I going to be subject to a subpoena? So that has a chilling effect. And then three, whether that there's actual legal action against you beyond that, right? Beyond just PR effective at all. And I think that is the thing we're all like in the back of our heads, kind of like the most concerned about from an academic standpoint for me, a reality standpoint for you and Ms. Owens. But you are 100% protected under many statutes and also the First Amendment. So, as long as it's still there and wasn't affected by the big beautiful bill, to report and have freedom that is protected to report on the as a member of the press. So, there's a lot implicated here, but the most one is like, why pick this fight out of all of them to go after people in the press when part of the image is that you are, you've retaliated against Baldoni. It's out there. Yeah, the complaint is gone, but like, this is not good. I don't know who's telling these people to do well in PR because they're doing terrible PR. They should have left well enough alone, and now this is a new front that I don't think will get much traction. I don't think a judge will order you to do anything. And if they do, like you said, well, that means you'll do things for both.
Bryan Freedman isn't just any entertainment lawyer. He's one of Hollywood's most feared, known for representing the industry's biggest names and high-stakes battles. His reputation is built on precision, shrewd strategy, and a knack for cutting through the noise. So when Freedman publicly accused Blake Lively of staging a false victory tour, the industry paid attention. But what's behind these bold claims? According to Freedman, Lively isn't telling the whole truth, and the story she's selling doesn't hold up under scrutiny. Freedman's frustration stems from what he sees as clear misrepresentation. In a statement, he accused Lively of completely mischaracterizing the court ruling to push her narrative. This ruling wasn't the victory she wants people to believe. It was, he said. Freedman even went so far as to call her publicity campaign a strategic distraction, alleging that Lively is blending emotional appeals with calculated media moves to control the public's perception. In his eyes, the court victory she's celebrating only tells half the story, or less. One of Freedman's sharpest points is how he's using the legal facts to fight back. According to sources, he's been pushing to highlight the actual wording of the ruling, which doesn't align with Lively's more dramatic claims. For one, Freedman notes that key parts of the case were not validated as Lively has described, but instead dismissed on procedural grounds, something he strongly believes her team is deliberately glossing over. In his view, Lively's narrative conveniently ignores the complexities of the situation, framing it as a clean-cut win when it's anything but. And then there's her media blitz. Freedman has openly questioned the timing of Lively's post-ruling interviews and public statements, which began almost immediately after the court's decision was announced. Her interviews were emotional and tailored for maximum public sympathy, painting a vivid picture of personal triumph and vindication. But according to Freedman, it was all a carefully orchestrated effort. He cites these moves as evidence of a broader PR campaign designed to obscure the legal nuances and amplify a one-sided version of events. Freedman doesn't stop there. He has also pointed to specific moments in Lively's statements where he claims she directly contradicts the ruling itself. For example, her repeated assertion that the court sided with her on every issue is something Freedman has outright called false. He argues that these claims are part of a larger narrative performance, one aimed at rallying public support while burying the less favorable details of the ruling. It's not just about winning in court, it's about winning in the court of public opinion, and Freedman believes Lively has mastered the spin. What makes Freedman's counterattack so striking is how directly it challenges Lively's public image, while her narrative hinges on empowerment and justice. Freedman's paints a starkly different picture, one of misdirection and media manipulation. If he's right, her victory tour might have less to do with the legal win itself and more with shaping how the world sees her. But does he have proof to back these claims? That's where things start to heat up. Freedman's next revelation, he promises, will leave no room for doubt.
Yeah, this does frustrate me, and we saw something similar to that in Depp Heard, where the ACLU aligned itself with Amber Heard and put its reputation on the line to protect what the jury found to be malicious statements about Johnny. Now, so we're kind of seeing something similar to that here. So what happens in court is that sometimes a organization or individual can go in and say, hey, I have subject matter knowledge or expertise on this issue, judge, that you're going to be reviewing. And so I am, as a friend of the court, going to present my kind of viewpoint on this to help you, to educate you, to make your decision better. That's fine. I've done it myself. These are these amicus briefs. Now, what happens, though, is that a lot of times they come in there just to advocate for a position on behalf of a party as if they actually knew what they were talking about as to the underlying facts when they have no clue what happened. Now, all of these organizations, and they may be all perfectly good organizations and super expert on the areas that they advocate for, have no better ability to determine truth from falsity than any of the rest of us, or certainly the judge. The judge does not need the National Organization of Women to tell the judge whether something happened or not. That's what we have a court case for, with testimony and documents and a jury or judge deciding it. So when I've looked at some of these briefs, what they're advocating for is saying protected speech by Blake. She had the right to speak out about the SA or whatever she was claiming, and she can't be sued for it. And there's a California law, which is California Civil Code Section 47.1. So 47.1 protects people who speak out against SA, whether they file in court or not, that they can't be sued for it unless certain conditions are satisfied. What these groups are seizing on is he can't sue her for this because this is protected speech and he is the abuser. You need to stop this, judge. We know what we're talking about. This is going to impact all women. What they're leaving out is that the statute says she cannot be sued for these allegedly defamatory statements that were made by her against Justin unless it was done maliciously, and her statements have to be factual. So they're leaving out those two really, really important, qualifications, and just saying, well, just because Blake says that I didn't, say anything wrong, and all my statements are true, therefore this is an affront against all women on planet Earth. That is absolutely ridiculous, way outside their area of expertise when they're not even properly applying the statute and do more harm probably to women than any help that they're doing.
What if Blake Lively's court victory isn't all it's cracked up to be? On the surface, her public appearances echoed the same message. She took on the system and triumphed. But when you actually look at the ruling, you start to see why Bryan Freedman is pushing back so hard. There's a stark difference between what's written in the legal decision and what's being said in front of the cameras. Let's start with what the court ruling actually handled. According to insiders familiar with the case, a significant portion of the decision wasn't about siding with Blake on the substance of her claims. It was procedural, meaning the court dismissed certain aspects of the case. Not because they were baseless, but because they didn't follow the technical standards required to proceed. One of the most buzzed about items in the ruling was the judge's acknowledgement that the situation was not entirely without merit. But that's a far cry from the sweeping endorsement Lively's team has been spinning. What about her repeated declaration that the court validated every aspect of her case? Freedman's interpretation paints a much different picture. Take, for example, a section of the ruling where the judge outlined the unresolved nature of a central complaint Lively put forward. The court didn't strike it down because of a lack of evidence, but rather because it was improperly filed under narrow legal standards. Procedural ambiguities like these are common in high-stakes cases, but Freedman views Lively's framing of the outcome as intentionally misleading. It's not so much a definitive win, he argues, as it is a middle ground. She's twisting in her favor. Freedman has been particularly vocal about the parts of the ruling that Lively hasn't mentioned at all. One specific section reportedly underscored the complexities of the case, with the court stating that while certain claims could be interpreted one way, they also left room for conflicting interpretations. This nuance, of course, has disappeared entirely from Lively's public statements. Instead, she's leaning heavily on select phrases that sound like complete validation, while leaving out the details that cast doubt on that narrative. And it's not just about what Lively's saying, it's about what she's not saying. Freedman is pointing to major omissions in her public account, including the fact that the court didn't provide resolution to some of her more controversial allegations by selectively emphasizing favorable parts of the ruling and ignoring everything else. Freedman argues Lively is controlling the public perception of a far more complicated outcome. In his words, the real story is too messy, so she's rewriting it to suit her. Now, all of this raises a critical question. If the ruling was as much about legal technicalities as it was about substance, how much of Lively's narrative can be trusted? Freedman firmly believes her public sentiment isn't an accident. It's a calculated attempt to turn half-truths into a winning headline. And as the pressure builds, his claims about her performance only grow louder.
prepping up. We are propping up Baldoni's side. No, I'm propping up the truth is what I'm doing here. Minus 4 million. The countersuit, that is until it was dismissed. In fact, it was popular YouTuber Signor via his channel Popcorn Planet and in the news, who claimed that exclusive featuring Baldoni lawyer Bryan Freedman's statement as to why the parties chose to forego amending dismissed lawsuits. Now, let me clarify, because I've seen a lot of anti-Justin camps out there trying to make this a story. It's weird how now TMZ seems to be parroting them. It's almost as if, Ron, there's a retaliation campaign on Team Blake come after us. Oh, the irony, isn't it? But I digress. Literally, countless anonymous accounts recycling the same talking points against me. The exclusive here was, you were on this video, Ron. The fact that I scored both you and Melcher was having both these experts on my video talking about it, and it did seem like no one else was talking about it, because this morning we were facing World War III, and I guess all the outlets later in the afternoon shared this same statement I had. It's not like I had something nobody else had. They just, I don't think, reported on it first. So yeah, the idea of this conversation isn't exclusive is really all I meant by that. And everybody's taking it out of context and trying to make it as if it's bad. Ron, you're a lawyer, Ron. Like, is it wrong of us to go reach out to parties involved in the news story to get official statements? Is that shady?
No, it's not shady. It's best practice amongst the press. You know, I have my own. I've been lucky enough to have my own media attention cases, and I always get calls from TMZ and other outlets to get comments before I do a story. So my understanding is that both yourself and Ms. Owens do the same thing before you go on. You ask for reach out to both sides. It's not your fault who decides to reach back out to you and give you any responses. So, and that's part of the role of the press, right? To have an opinion, and but a good journalist who does this is open to at least hearing from both sides and reporting that, even if you don't have to agree with one way or the other. You're not robots, and that's just the nature of what the press is supposed to be in this country.